We're here in the matter of the City of Gary et al. Versus the Honorable Mary Beth Bonaventura et al. 45 CO 11302 PL 11. For the record, would everyone identify themselves and who they're representing?
Good morning, Your Honor. Wade Hornbacher, Deputy Attorney General, representing Judge Bonaventura and Judge Sarah.
Judge Serrano, the City Attorney General, representing Judge Bonaventura and Judge Sarah.
Cousin Davis, representing the City of Gary. Barbara Bowling, representing the City of Gary, City of Chicago, Your Honor.
Percy Drake, representing Carlton Mahone, claiming the case.
Eric Clark, I represent Carlton Mahone as well as Jamie Cobb, named plaintiffs.
All right, and we're here, have some preliminary motions here that maybe we should address before we get going.
Before we get to that, Judge, I move for a default judgment against the defendants for failure to appear. Because in the event this hearing is forward, they are not here, they cannot defend. And since they are not here to defend, we would ask for a default.
Your Honor, if I may, Judge Bonaventura and Judge Sarah are both in the building and available if necessary. They're not in the courtroom right now because we have preliminary matters we have to deal with first, but they are both available today.
Your Honor, being available, this proceeding has begun, and we've moved for default because they are not here in the courtroom where they should be as defendants.
I don't know that that's a ground for default. Any party may appear in person or by attorney, and they have appeared by attorneys in the Indiana Attorney General's office.
Well, let's get into it before we see what there need to be here or not. All right. For right now,
Your Honor, we would begin by, well, we're ready to call our first witness.
Well, let's proceed. We have a couple of preliminary matters here. First, we have a motion for extension of time to plead.
That's to file our answer, yes, Your Honor.
Yeah, that's automatic. I mean, you get an automatic extension under our rules. So, this was filed February 21st, so I would think you have till March 21st to respond, to plead. Okay?
Yes, Your Honor.
So that one's out. And we have a motion for a change of venue.
Yes, Your Honor.
Your Honor, our position, if I can be heard on that.
Yeah.
Your Honor, it's my motion. I think
Is there a motion right there? First,
I
proceed and you can be heard.
Your Honor, our motion for change of venue comes both under the trial rules and the statutory sections cited in our brief. The fact of the matter is that we're entitled to an automatic change of venue when, as is the case here, a party to the lawsuit is the county or a county entity. In this case, the county judges, two of them, are defendants in this lawsuit. Just as if the county clerk were a defendant, the county treasurer, the county surveyor was a defendant, under both the trial rules and the Indiana Code, we would be entitled to a change of venue. Another kind of automatic reason we would be entitled to a change of venue.
The judges, county employees, they're state employees.
They're state employees, but it's a county office, the Lake County Superior Court. But even if it weren't, the way plaintiffs have pled their amended complaint, and I think that's something that just needs a little bit of background, is since this case was removed from this court, all the federal claims were dismissed out of it, and it's been remanded back with a new complaint that has just state claims in it. The claims that they have in their complaint, one of them relates to whether the judges of the unified court system should have voted to move the court out of Gary and back to Crown Point. As they're bringing internal workings of the judiciary in Lake County into question, all of the judges of the Lake Unified Court System, Your Honor, include our potential witnesses in this matter as to what votes may have taken place or not taken place prior to the court moving to Gary, and what actions have been taken by the judges if they sought to have a vote to move the court back to Gary.
Your Honor, on behalf of the plaintiffs, learned counsel makes an argument with respect to the judges of Lake County, which is our position is not well taken. The lawsuit specifically names two judges. The two judges that took an action were the other judges, What he seems to suggest is that they are some facto parties. Can't think of the Latin word. I want to say ipso facto or something, but they're not parties. Anybody can be a witness. And with the discovery that the state has provided, there's no reason to even call technically any of the judges to show what was in fact done by the named defendants in this case. Secondly, under the change of venue, Rule 76, I believe, emergency matters remain with the judge from which they have been filed. Okay, we have never had a hearing on our emergency matter. The court will recall that when we first came, was it February 8th? February 1st? When we first came on February 1st, Mr. Hornbeyer, I hope I pronounced your name correctly, appeared by telephone and really asked for continuance. When he asked for continuance, the matter was then venue to the federal court. We amended the complaint. The matter was remanded back to this court. Under the trial rules, the court then sets the matter for a hearing. Having received no order setting the matter for a hearing, we contacted the court to get a hearing and coordinate a hearing, and we ended up here. We ended up, in fact, here today. So our emergency matter is still pending. And since the emergency matter is still pending, Your Honor still has jurisdiction over the emergency matter with respect to our, and that's our preliminary injunction, with respect to a hearing on a permanent injunction. The council has properly raised the change of venue and is entitled to a change of venue, which is more or less automatic, and he can state whatever grounds, if it's to the judge or to the county, in accordance with the rules which they have. But we believe that the emergency matter, this court has jurisdiction of the emergency matter, and we are here prepared to proceed on the emergency matter. The defendants are not here, and by them not being here at this moment, that's going to cause a delay in dealing with the emergency matter. Thank you.
Your Honor, if I may just briefly.
Your Honor, sir, if I might, representing the city of Gary, I think I'm about to. Let me just say, the issue here is access to the courts. That's our complaint. Not whether the judges voted together or separately. This access to the court that is being denied by the move of the 4D court from Gary.
Whether they voted or not.
Correct. So it doesn't, so whether they voted is not relevant to what we're trying to do, is to provide access to the court to the citizens of North County, particularly Gary, East Chicago, and Hammond. And we have witnesses who are here and available to testify concerning the impact of the move of the court on the citizens in North County, North Lake County. With regard to the change of venue rule, it is, I believe I filed our objection to this change of venue. I don't think they are entitled to a change of venue because
I don't think I have some of the pleadings that were filed in the case. I don't know if I got your...
You didn't receive a copy of the objection?
I don't believe I have. Let me make sure. I have your motion for immediate hearing. Thank you.
Okay. The defendant's statement that the judges are something like a county employee isn't what the rule states. It doesn't say, it says you have to be a county. You have to be part of the county to give you the automatic right to change a venue. They're not the county, and it doesn't say you can be something like, because I could be something like, because I live in Lake County. And if I was employed by the county, then I would be something like the county. So every suit where anyone was employed by, I can't understand the analogy where Mary Beth and Judge Bonaventura and Judge Kara are state employees, but they're paid to this court under the change of venue rule to be like county employees, but they're not. And that's what the fact is. Trial Rule 76, in any event, we want to proceed because Trial Rule 79.0 specifically provides that emergencies, nothing in this rule shall divest the original court and judge of jurisdiction to hear determine emergency matters between the time a motion for change of venue is filed and the appointed judge accepts jurisdiction. We haven't even gotten to that point yet where you would have made a determination that change of venue was appropriate, which we don't think it is. But even if you did, today, this matter should still proceed because Indiana, in the city of Gary versus Enterprise Trucking and Waste Hauling, Inc., at 846 Northeast 2nd, page 234, a 2006 case states, we note, in Hoagland, we noted a trial court would have jurisdiction to grant a preliminary injunction pending the perfection of a change of venue. So, Indiana case law says this court has jurisdiction to grant a preliminary injunction pending the perfection of the change of venue. So, I don't think the change of venue motion needs to be heard prior to our evidence concerning preliminary injunction. But even if it is, we're still entitled to proceed on our motion.
If I may respond briefly, Your Honor. Two things. Under the trial rule, there are two grounds that we're claiming gives us a right to change a venue. A suit against the county. How we get to Judge Bonaventura and Judge Pera being tantamount to that is that this suit is brought against them in their official capacity. This is an ex parte Young style thing where a official capacity suit brought against an official in their state, in their official capacity, makes them tantamount to the political subdivision. The other area we have is that where a judge may be a material witness to it. We didn't make it up that the fact that there was no vote is something that's being alleged. That's right out of plaintiff's amended complaint. That's paragraph 8 of their amended complaint, where they say the decision to remove the 4D court from Gary was made without the approval of the judges of the Lake Superior Court. That's an allegation that they put factually at issue in this case. That's something that's going to have to be looked into, because whether the judges voted beforehand, or since this is a purely internal matter for the judges to decide where sessions of court are held, whether any judge afterwards spoke up at a future judicial meeting and said, no, I want to move it back, that becomes relevant, and that makes the judges all in Lake County, or at least those that were present at those meetings of the unified judicial system, witnesses. With respect to what is an emergency, the court has been moved from Gary to Crown Point for almost a month. There's no longer an emergency there. If we have to go forward and put on evidence, the evidence will show that there's been no change in the number of people that showed up to hearings in Gary as they did to Crown Point. Further, a preliminary injunction isn't this kind of emergency thing that's looked at. If this were a TRO hearing, that would be different. Maybe that would be an emergency. But there, both TROs and preliminary injunctions look to maintain the status quo. This isn't maintaining the status quo. The status quo right now is that the 4D court is now in Crown Point and no longer in Gary. On top of that, if we get beyond the mandatory reasons for change of venue, within some of the discretionary realm, there's the fact that this case deals with 4D jurisdiction, juvenile 4Ds. The Lake Superior Court itself has some 4D jurisdiction. It hears UIFSA 4D cases, and it's very similar to 4D cases here. So I think there's ground for change of venue and no reason to go forward with an emergency motion. We're not here trying to slow this down or anything. We're willing to, as soon as we can get a change of venue, we're willing to do a consolidated preliminary injunction and final trial on the merits at the selected venue's next available opportunity. If the Honor wants to incorporate that into any order changing venue, that I think is appropriate. We're not trying to delay this. We're willing to strike counties today. We're willing to get on whatever the new venue's next available slot is for a half-day trial and put this to bed forever. We're not trying to delay this out by setting another hearing. We're willing to keep this rolling along and moving, but we really think that it needs to be venued for the reasons stated in our motion and here today, that it needs to be venued out before anything's done. And I don't think that if we've had a month go by with the court having moved, with there being no change in the number of people that are able to make it to their 4D hearings, that if we wait till next week and get it accepted by another judge and have it heard there, and even if we consolidate it all and just do a final trial on the merits, let the judge hear the preliminary and the permanent injunction together and have it done, there's no harm to the plaintiffs. There's no more danger with it being a month or a month and 5 days. So, Your Honor, we think the change of venue is something that needs to be addressed right now, and no other matter should be, because this isn't what the trial rules envision as an emergency where something's going to happen. It's already happened. There can't be a TRO that enforces something other than the status quo, and only in the most extreme circumstances can a preliminary injunction be granted where it doesn't just maintain the status quo. And there's never a circumstance where a mandatory injunction, one where it orders some other party to do something else, can be entered if that preliminary injunction is going to be the same as the permanent injunction. And that's the Indiana Pacers versus Leonard case from about 10 years ago from our Indiana Supreme Court. So I don't think that there's any reason not to just venue this out, get on a rocket docket or the easiest, quickest hearing we can have in the new venue, and resolve it there. There's no reason to go through it all today and then have to go through it all again sometime in the not too distant future. So for those reasons, there's no emergency, Your Honor, and no reason venue shouldn't be changed.
Your Honor, if I may, and then Attorney Taylor and Attorney Drake wish to address the court on this matter. If we were dealing with a court of smiles and good feelings, counsel's argument perhaps would be well taken. However, we are in a court of law. The court has before it our complaint that was signed and filed on February 1st. On February 1st, the 4D court was located in Gary, Indiana, and what we commonly refer to as the 4th or 5th and Broadway. The purpose of the preliminary injunction, counsel is true, is to preserve the status quo. With the date that the filing, the status quo was the court was in Gary. The judges knew that the case had been filed and proceeded to move the cases to Crown Point that Monday. That's uncontroversial. We have not been able to have a hearing sooner. It is an emergency matter because it becomes an issue of access to the courts and people being able to get to the court. What counsel tries to do is trying to defend the move, and that's not what the rule on injunction so speaks to. At this time, I would refer to counsel Attorney Davis.
Now, the local Lake County rules concerning preliminary injunction states the general purpose of a temporary restraining order and preliminary injunction is to maintain and preserve the status quo until the merits of the case can be heard. The status quo is the last actual peaceful and non-contested status which preceded the pending controversy. And then the court cites Reeves versus Panhandle Eastern Pipeline Company at 176 Indiana Appellate Court 597, 377 Northeast 2nd, 640, a 1978 case. An injunction doesn't create or enlarge the rights of the parties, merely protects existing rights, prevents harms to the aggrieved parties that can't be corrected by final judgment. That's what we're here for. Our clients' rights can't be protected. Our clients' rights, people of the city of Gary and the city of Chicago, as well as the plaintiffs and other citizens of North Lake County, cannot be protected if we allow this matter to be drug on. Because the reason we are here today is because council moved forward to remove the case from your court, and that caused a delay, and now they move for the change of venue, which is going to cause another delay, and whatever the rocket docket that they are referring to, we didn't have a rocket docket in February, after February 1st, when we first got into this case. And I can't see that our clients should be denied, continue to be denied access to the 4D court in the city of Gary because council wants to go to another city to have the ultimate decision on our permanent injunction enjoining the court from moving to be heard.
Anything else?
Just so that we make the record.
If I could, before Sean got to proceed, there's one other thing we're trying to brief the court's attention, perhaps, to Sean about as well. His argument seems to imply that the juvenile court judge and Judge Bonaventura and Judge Perry are employees of the county. I think the court can judicially note that judges don't get paid by the county. They're not employees of the county. There is no judiciary in county government. Title 36, 2-3.5 defines the subdivisions of the county government as the official, administrative, and the executive. There's no county judiciary. So what defendants have argued is actually not in it. There's no judiciary officers who are employees of the county. And we ask the court to judicially note that, and the statutes clearly bear that out. The additional thing is the preliminary injunction asks for things while this matter is pending. That's why it's called preliminary, and that's what is needed. There are people here who are suffering, and I think the evidence will reveal if the counsel isn't able to borrow the witnesses from testifying that there are people who are suffering irreparable harm. Now, the fact that they were suffering it a month ago and they continue to suffer, there's no reason to cause a delay. It's a case of justice fund delay will be justice denied.
Just briefly. Judges are, as your honors would no doubt be aware, are paid by the state, but they serve in a county office for a specific county. The logic behind the rule is behind wanting a change of venue in the county's parties, we don't want the county deciding matters that deal with the county. Same thing is here. We don't want one county judge deciding a lawsuit with one of their colleagues who's also on the bench, one of their colleagues, a fellow judge. It makes sense that falls under 3435.11. The only other thing I want to clear up very briefly is the defendants aren't the ones that are responsible for this delay. When the complaint was originally filed, it included a federal First Amendment cause of action. Defendants had an absolute right to remove that case to federal court. And plaintiffs, as the individuals who control the case that they bring, decided to remove that claim and insert an Indiana constitutional claim. At that point, the case was remanded back for lack of federal jurisdiction. They could have left their federal claim in there, they could have added their state claim, and it would have stayed in federal court, and we could have had the hearing that was scheduled the following Monday. But they didn't. They took it back out, caused the remand, and that's what got us back here So trying to cast all the blame on any delay on the defendants is simply not fair. And other than that, I just reiterate what we said before, is that we are not trying to delay this, and we're willing to do everything possible to adjudicate it as soon as it is moved to new venue.
Your Honor, if I may. In the interest of not having to prolong this, I wasn't going to say anything, but I can let something that was erroneous stand, and that is that the plaintiffs have included a federal question as part of our counts. We listed 2 counts. Neither one of those counts talked about any type of federal question. There was a mention in the statement of the facts that talked about the United States Constitution, but it was not part of any of the claims that we put forth. So that there would not be any confusion, that is why we did amend it to just remove that from that statement of facts. But there was never a federal question.
All right. Anything else? Okay. We'll proceed on the preliminary injunction. I'll take the motion for a change of venue under advisement. You filed it February 15th, so I have a few days to decide on that. So let's proceed with the emergency petition. Here's some evidence.
Your Honor, we call Mary Beth Bonaventura.
She's outside. Jeff is going to get her. But in the meantime, I'd move for a separation of witnesses, Your Honor.
All right, granted. That's good.
And Your Honor, if I may, we've also prepared, in case it got to this, a brief in opposition to preliminary injunction, which I'd like to distribute now. May I approach?
Swear to Jeff.
Raise your right hand. Swear a firm testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
I do.
State your name for the court, please.
Mary Beth Bonaventura.
Please state your occupation.
I'm the senior judge of the juvenile division of the Lake Superior Court.
And the Lake Superior Court, the juvenile division, is that a part of the Lake County Superior Court?
Yes, it is.
And you have been judge of the juvenile division for how long?
20 years.
Now, we're talking today about the 4D court, which on February 1st was located in Gary, Lake County, Indiana. Now, the 4D court that was located in Gary, or that had hearings in Gary up until February 4th, I believe.
Objection leading.
Well, Judge, I believe this is what's called an adverse witness, and so she's also a party, and so leading questions are proper.
Your Honor, he's chosen to call her on direct examination. I think he needs to ask some more.
Just ask the question. Just rephrase the question.
No, she's still an adverse.
Well, let's see how she answers.
All right. Now, Judge Bonaventura, the 4D court in Gary came into being in 1982. Is that correct? And in 1982, that court was that court supervised by Judge Swetnoff?
Objection again leading, Your Honor.
And once again, she's a party. You can ask leading questions, and unless counsel cites the rule of evidence, I would ask that the court admonish him to either cite these.
Why don't you ask her if she knows who supervised the court back in 1980?
Well, I don't want counsel to direct my case, and I think that I'm trying to go through this, and we have a right to ask these questions because she is in fact a party, whether I call her on direct or not.
Counsel?
Your Honor, he hasn't shown her to be adverse in her question or any way impeding his ability to get answers out of her. I believe the rule is 611C. Until she's shown to be somehow not answering his questions, I think he needs to ask leading questions, or rather, open-ended questions.
Judge, the rule, very simple, says if you are a party a party, if he's an adverse party, the other party can ask leading questions. And that's the rule is leading questions, which is Rule 612C. Leading questions should not be used on direct examination of the witness, except as may be necessary to develop blah, blah, blah. Ordinary leading questions should be permitted on cross-examination. Whenever a party calls a hostile witness an adverse party or a witness identified with an adverse party, interrogation may be by leading questions. Now, unless counsel has a case that says something different than Rule of Evidence 612, which I would point out that our Court of Appeals and Supreme Court says objections must be stated with specificity, which translates into...
Let's hear his objection, Mr. Clark.
My only objection is, or my point is the prior rule, or the Rule of Evidence is clear. It's may allow. It's within the court's discretion to allow leading questions, and all I ask is the court to make a ruling on my objection. I don't need to argue with Mr.
You can proceed. I don't see any...
Okay. Now, this court was instituted in 1982.
Correct.
And the court was originally, the 40 court is under the auspices of the, when it was originally instituted, it was under the auspices of the Lake County court system, correct?
Correct. The juvenile court.
Well, 1982, the juvenile, Judge Mears was the judge in 1982.
Correct.
And the 4D court was not administered in 1982 by Judge Mears.
Yes, it was.
All right.
To my knowledge, it was.
To your knowledge.
Yes.
Okay. And so, if it was to, all right, we'll keep going. And that, now, in our request for discovery, we asked that you provide us with documents showing the contract for the 4D court with the Indiana Department of Child Services, correct?
Yes.
Okay. And you provided some contracts to us, I believe, dating from, well, the most recent one you provided to us is from 09, is that correct?
I thought I provided you with contracts from 06 through 012, or through 12.
Oh, okay, I'm sorry, I didn't see 12.
We didn't get 12.
Okay. Because the last one I had was, okay. All right.
Are you approaching the witness?
No, I'm just,
Which one's your first? Claims
Now, the 4D program, is it fair to say that that is a program between the state and the county?
The 4D program, I guess you could say it that way, but the 4D program originates from the Social Security, which is the Social Security Act, which is through the federal government.
Okay.
So that's why the county gets 66% of any money they spend is reimbursed by the federal government.
Okay, well, let me restate that. The 4D program is a federal program administered by the state, but implemented by the county. Would that be a better way of putting it?
Probably, yes.
Okay. Now, and in fact, the contracts that are entered into every year are between the state and the county, correct?
Correct.
Yeah, Madam Judge, that's the process.
Yes.
Now, I placed in front of you plans exhibits 1 and 2. Can you identify those?
Exhibit 1 is the cooperative agreement for the federal financial participation of the 4D court, and it's the same thing for Exhibit 2. One is for 2009, one is for 2011, calendar year 11-12.
Okay. And these are agreements between the state and the county to implement the 4D program, correct?
Correct.
All right. Now, Your Honor, this time we move to admit plaintiffs 1 and 2.
Any objections?
No objection, Your Honor.
Plaintiffs 1 and 2 is admitted.
Now, is it fair to say that there came a time when the 4D court, the 4D court, until February of 2013, has always been in Gary, has it not?
One of the 40 courts, yes.
Well, when did a court is created by the a court is created by the state, correct?
A state court, yes.
And the 4D court is a federal program implemented with a contract between the state and the county.
Yes.
Now, and isn't it true that until 2 years ago, all of the 4D cases under this contract were heard in Gary?
Until, yes.
And I believe in one of your responses, I saw somewhere here, that is it your claim that the 4D court in Gary is a satellite court?
I guess, yeah, I guess you could consider it a satellite court, yes, because the court itself functions in Crown Point.
Now, when we talk about satellite, is it fair to say that a satellite is something which is broken off from a larger part?
Probably, yes.
And then if we're talking about something broken off from a larger part, we would kind of be into the existentialism, the chicken before the egg. You can't really have a satellite if that existed before the other part came into existence, could you?
You mean could the 4D court exist without the court in Crown Point?
No. The court already existed in Gary as a 4D court. You started hearing cases in Crown Point.
Well, the 4D court is part of the juvenile court. And so the second court in Crown Point is part of the juvenile court as well. There are just 2 4D courts assigned to the Superior Court Juvenile Division.
Judge, is that what the statute says, or is that your interpretation?
I haven't read that statute that provides for that. All I know is that in 1982, the first 4D court was implemented and was under the supervision of Judge Mears. At some point, that was then supervised, I want to say, by Judge DeNicholas, because Judge Mears asked him to take supervision of the personnel over at some point because of something that happened in her office. I don't know, it's when she was judge. So Judge DeNicholas then supervised it because he was chief judge. And so every chief judge thereafter, myself included, I was chief judge at one point, supervised the 4D division after I became judge in 93. And then in 2006, when Judge Para became chief judge, there were some personnel issues, and he called me because always, and I know you know this too, Mr. Clark, that always juvenile court has exclusive jurisdiction over paternity matters, which is why the 4D court is part of the juvenile court. We have exclusive jurisdiction over paternity matters. So at that point in 2006, Judge Para asked me if I would take supervision back over because it made sense with everybody worked for juvenile court. And so rather than him deciding about vacations and sick days and things of that nature, and I was already signing all the orders that came out of that court, he said, will you take it back over? I said, absolutely. That's why you only got contracts from 06 to 12 that I provided for you, because the ones prior, I'm guessing Judge Para has.
Okay. But the 4D court is more or less, it's a part of the Lake Superior court system.
It's a part of the juvenile court system.
Well, when we say it's a part of the juvenile court system, let me just ask you this. Isn't it true that there's no state statute that says that the 4D court is a part of the juvenile court system?
I don't know the answer to that, to be honest with you. I really don't.
Isn't it true that the county has passed no legislation saying that the 4D court is a part of the juvenile court?
I have no knowledge of that. I don't know. I wasn't aware that the county could pass legislation.
Okay. Now, before moving this court, the 4D court, in fact, the 4D court has always been referred to as the 4D court, has it not?
The 4D juvenile court, the division of, I guess, the 4D court.
4D court. Okay. Now, did you receive a memo from John Doe advising you that based on Indiana Code 33-35-14, I believe it is?
I'm going to object, Your Honor. What's the relevance of this? What Mr. Dole has to say?
Let's finish the question.
Did you receive a email from Lake County Attorney John Doe advising you that, in his opinion, as a county attorney, you did not have the authority to move the 4D court?
Same objection, Your Honor.
Overruled.
I don't recall everything he said in the email or fax. I can't remember how I received it, and I don't recall all of it, but the gist of it was that, he didn't think it should happen the way that I was preparing to move the court.
Now, are you familiar with Indiana Code 33-45-13, which speaks about location of courts?
I am.
And this is the statute which says that if a court is going to be moved, it requires the judges of the county to make a decision as to where the court should be, correct?
I'm going to object, Your Honor. I believe he's misinterpreting the statute. I think that's a matter for the court to decide the law.
Your Honor, that's for him to ask on cross-examination. That's not a valid objection.
Your Honor, a witness is a fact witness. She can't testify as to the law. That's something for the courts to decide.
Your Honor, this is... well, counsel makes an effort here, but he stated no legal objection. He says that this is a fact witness. This is a witness that has already said she's familiar with what the law states. And I don't think it's necessary that we read the statute into the record, but...
Well, is that what the statute says?
Excuse me?
Is that what the statute
Yeah, that's what the
says?
statute says. Exactly what I asked.
He disagrees.
I do disagree, Your Honor. I think that's part of what this case is about. I think the statute speaks for itself. The court can take judicial notice of what's written in the Indiana Code, and I don't think we need to have extensive examination of Judge Bonaventura as to what the statute says or what opposing counsel's interpretation of the statute is and whether she agrees with it.
You know, once again, that's not a valid...
Well, why don't you ask if she's familiar with the statute?
Judge Bonaventura, are you familiar with the statute, are you not? 33-45-13?
I am familiar with it. I haven't read it in a couple of weeks. I couldn't tell you verbatim what it said, but I am familiar, yes.
Location of court sessions. IC 33-45-13, Section 13. The court shall hold continuous sessions in places in Lake County as the court periodically determines. The Board of County Commissioners of Lake County shall, 1, provide and maintain a suitable and convenient courtrooms for the holding of the court, together with suitable and convenient jury rooms and offices for the judges and other court officers and personnel. B, other facilities as may be necessary. And 2, provide all necessary furniture and equipment for rooms and offices of the court. Do you know that to be what the section, what the court says, what the that section says?
I believe that it does.
And Indiana Code 33-45-6, is that the statement which sets forth the jurisdiction of the juvenile court?
I don't know the code side.
All right. If I were to tell you that Indiana Code 33-45-6 provides, notwithstanding Indiana Code 31-30-1-2, the juvenile court shall have exclusive jurisdiction over a child who, 1, has been taken into custody of the county, and 2, has allegedly committed an act that would be a misdemeanor traffic offense if committed by an adult. Would you dispute that?
Your Honor, I'm going to object. Counsel is testifying, and that's not allowed under Indiana Evidence Rule 603.
Your Honor, I'm asking her if that's what she knows the statute to say, or if she...
Are you asking her what jurisdiction she has as a juvenile court? Is that what your question is?
I asked her if she recalled the statute.
Your Honor, I don't think it's fair to just go through the Indiana Code piece by piece and ask the judge if she remembers that he can either show her the statute or just move on to fact-based questions.
In that matter, Mr. Clark.
Well, Your Honor, that's called... the witness has to first say they don't recall, and then that's a refreshment of recollection.
But you didn't ask her if she recalled.
I asked her if she recalled that statute.
No, I don't think she answered, did you?
I mean, I know that that statute exists, what it says. I don't recall. I haven't read it in, gosh, years, probably.
Yeah. All right. Your Honor, if I could just take a moment.
Let's take 5 minutes break. 5-minute recess.
All right.